many, many, many burn cases. And they both described for you situations they have had where they know that it took 2 hours for the patient to get from the place where they were burned to the hospital. And those patients were in better condition. They told you why, based on their training, their education, their experience, why this was a case of delay. Because had it been immediate, she would have been responding. Her organs would not have been failing. Her body would not have been so terribly dehydrated, and she would not have been on the brink of having cardiac arrest. And her skin would not have already been as leathery and as constricted as it was. Now, they also described for you some evidence that's important for count 1, because you have, right? I told you what happened, but testimony that her mom is the one who did this to her is consistent with the medical evidence that you have in the case, because they all describe for you the pain response. And one of the jury instructions mentioned common sense. This is one of those areas where you can rely on common sense. You can rely on the life experience that you have. That reaching out and touching the hot teacup, or the burner on the stove is no longer orange, but is still hot. And what happens when that happens? You pull away. You don't ponder, gee, that seems hot. Maybe I should take it off before this first-degree burn becomes a second-degree burn, becomes a third-degree burn. Because before your brain even registers that you've been injured, your spinal cord is snapped into action and you get pulled back. A healthy child was a healthy child. Does not just let herself sit in that situation while first-degree burn becomes a second-degree burn, becomes a third-degree burn. She just does not do that. Dr. Crampton told you that. Dr. McCruson told you that. This is a case based on their experience, their training, that is not accidental. The only way a child stays in this situation for long enough to sustain the injuries, the skull burns that she had, is that she is unable to get out of the tub. And ladies and gentlemen, that supports, that corroborates what I told you on the stand. That she was unable to get out of that tub because her mom was holding her in. While she was doing other things besides calling 911, Samantha Osteraas was not in shock. That's not shock, ladies and gentlemen. You can use your common sense there too. She told you today that she doesn't know pain. She said something very similar to that yesterday, comparing her pain. But a parent who is faced with a situation where their child is injured does not wait. Does not make 9, 10, 12, 15 different calls to different people before calling 911. A parent who is truly in a state of hysteria and wants to get in touch with the neighbor firefighter isn't making 9 calls to his wife and a couple of calls calls to him. She's picking up her child and running out the front door and running down the street to find the firefighter. But that's not what Samantha Osteraas did. And that is because she had done something bad. And she was hoping on hope that she could just wait and maybe things would get better. But as we know, things did not get better. And finally, when she finally called 911, it was literally on death's door. That's the evidence that you have, ladies and gentlemen. And that evidence proves to you that Samantha Osteraas is guilty of committing child abuse, both for the burns themselves, because that's what I told you. This testimony is corroborated by the medical evidence in the case, but she's also guilty of child abuse because, look at the pictures, look at it. That is a child who needs immediate medical attention. And the doctors told you there was a lengthy delay. Several hours, many hours. They can't tell you exactly by stopwatch how long it was, but it was much longer than any ride in an ambulance from the house to the hospital would take. She is guilty of child abuse for not seeking that medical attention when it was clearly obvious to her that her little girl needed it. And for that reason, the state's asking you to find her guilty of both count 1 and count 2 of the indictment.
Revolutionized sort of the beginning of how jurors can participate in the case. This was one of the things that he helped create, was jurors asking questions and jurors taking notes. You might think this is crazy, but murder cases are actually kind of easier than other cases. Seriously, and more seriously, and more seriously, and it all depends upon the state of the mind of the person. The legal limit, they didn't perceive a risk that they should have. The person crossing the crosswalk, you ran their life and hit them. It's a less serious, it's a very, very serious offense, but it's less serious. And then we have the lowest form of the crime, which is negligent homicide. And that might be somebody who was just speeding and couldn't stop fast enough. They were speeding way too fast to hit the person in the crosswalk. It might be a person who has some drinks, is close to the legal limit, didn't quite cross it, made a couple other traffic mistakes in the way. And there are many other ways to commit all of these offenses. I'm just giving you the ways that are typically crimes. And so then we go down to the same event. Okay? Same car, same blue car, speedway cameras. This person is not speeding, they're not drunk, they're not doing anything wrong, but something distracts them. They get some other event distracts them. Spill coffee in their lap, and they reach down and they inadvertently kill the person by running. That is not a crime. That is a crime that is covered by civil negligence laws. And some of us have been rear-ended. I've been rear-ended twice. Once I thought we were going to survive and run for all the hay in the back of the pickup truck. But the fact is that person didn't commit a crime, but they did, hit me, and it was their fault, and that was a civil case that a person could sue someone over, but it was an accident. So these are all what fancy Latin term is mens rea. It's something we all lawyers look at, and prosecutors particularly look at it when they are thinking about whether or not something is a crime or not a crime. And it is I'll give you another good example of one of the very first cases I had in my career. Person had been drinking, wasn't over the legal limit, was in a dark place in South Dallas Highway. There were no street lights. He was going the speed limit. He made no traffic errors, did nothing wrong, but a woman walked right out in front of his car. He hit her, he was going the speed limit, and killed her. It turned out she had cocaine and marijuana in her system, and she wasn't in a crosswalk, and he wasn't at fault, but he had killed someone. So the reason I tell you this is because you're going to have a lot of choices here in this case. I maintain, and my client maintains, that this was an accident. And the guy who was distracted momentarily, and she was distracted that night as well by other things she was doing. 4 children, and that's a fact. Let me go through a few general principles. Some of these we went over in opening statement. We talked about the presumption of innocence, burden of proof, who has it and why, and beyond reasonable doubt being the proof. I showed you this chart, and the judge was gave reasonable doubt instruction talking about preponderance of the evidence case, civil case. That's just over half. Just tipping the scale one way or the other is enough. And we'll talk about clear and convincing what that means, and beyond reasonable doubt being the highest burden of proof that we have in our judicial system. The case that I laid out for you. I like to think that this is sort of my promise of what the testimony and the facts will tell you. And we heard a lot of this from we take you through their day, which was a routine day. Kids go outside and play after breakfast, after lunch, they take a nap. Snack also takes a nap. They wake up, have their late afternoon snack. Kids play with various things. A little schoolwork with the children. Kate comes by around 3:30. And then these times are very approximate. The only times we know absolutely for certain are the ones that are pulled off with the cell phones and iPads and other things, because those are fairly certain. Samantha makes dinner. It's a routine day. She told you what she did. Kids play on their computers, play with Legos, and do other things. And then we heard that she did a search on her computer or laptop or iPad. I'm not familiar with all these things, but just to get ready for bed. These times are not exact. But at the time, she was trying to multitask. Like any mother with 4 kids would be doing. You've got 4 kids, you've got to prepare them for bed, prepare meals, you've got to take baths, you've got to get all these things done. And she's also folding laundry in the bedroom, which is just a few steps from the hallway bath. Okay, take a bath. She goes in to wash, grabs a loose towel in the room, and you'll notice that in one of the breaks, after she turns the water off, that's when she goes into the room to get the towel. That couldn't happen because it was a crisis. It wasn't the routine, shut off the water, and then we'll go over and get the towel and bring it back, because it was a crisis. So then she plugs the drain and turns the water on. So standing nearby, and she walked out. Samantha goes to the boys' room, helps them get things ready, grabs his iPad, gets all moved into the master bedroom. And then we get here. She went to turn the water off in the bathroom. Her chin folded, her arms on the ledge of the tub. Now remember a couple of things here. One is that they said the left arm was not third-degree burns. Why? Because whatever he was exposed to probably wasn't exposed to as long, because it was now out of the tub, on the ledge of the tub. The other arm over here, the other arm had a cast on it, and her head was leaning down on it. Samantha empties the tub, as you heard from her, and because she doesn't want anybody else exposed. At this point in time, she goes straight to the master bedroom and lies her down. She goes back in the bathroom, drinks the tub, as you said. But she didn't say anything to the children at this time, but Jeff kept crying. She's very upset. You saw the body of this young girl, what it looked like. Okay? So when we see this rash of phone calls, they happen at 7:46. Okay? It has to be right after the time. Because if there was a huge delay, why wouldn't she have been researching burns an hour before or 30 minutes before, any time when all of this actually occurred? Why wasn't she doing that stuff before? Why wasn't she making frantic phone calls before? It had to happen right before the first frantic phone call. Let me tell you a couple stories about my family. And I bet if you think hard, you can find some stories like this with your family. My mom came here in 1977 to teach at the University of Arizona. And as part of that, she moved out here with my 3 younger brothers and my stepbrother. And there were conferences she had to attend because she was supervising some other teachers. And she once went to one in California. And at that California conference, she was alone. My stepdad was